This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Justice Department's indictment of James Comey was riddled with problems that may give the former FBI director legal grounds to have it dismissed. And that's according to a federal judge. Comey's been charged with making false statements and obstructing Congress. And Magistrate Judge William Fitzpatrick cited 11 potential missteps by the Justice Department in the lead-up to filing those charges, including fundamental misstatements of the law to the grand jury by the prosecutor, Lindsay Halligan, and the use of potentially privileged communications. And he's ordered an extraordinary remedy, the release of all grand jury materials to the defense. That's been put on hold pending a review by the district court judge. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter & English. Bob, in some ways, the judge's opinion seems like a guideline for the defense to ask for a dismissal of the indictment. He outlined the procedural and substantive irregularities that occurred before the grand jury and said they may give Comey legal grounds to have one or more of the counts dismissed. Pretty harsh condemnation of the government's actions.
It was extremely unusual because it's extremely rare in the first place for a judge to be reviewing conduct in front of a grand jury. So what the magistrate judge was tasked with in this circumstance was to decide whether Mr. Comey had met the very high bar for a defendant to be given full access to the transcripts and recordings of a grand jury proceeding. What ended up happening here was that in addition to the reasons that Comey's lawyers had argued for access to the grand jury material, the judge found from his own review of the materials a host of new problems, new issues that could ultimately lead to the dismissal of the case. The judge went through a series of potential issues that he decided the defense was entitled to probe and to raise before the court as a basis to possibly dismiss the indictment. One of the original issues that Comey's lawyers raised as a basis for accessing the grand jury material had to do with search warrants that were executed by the Department of Justice in 2019 and 2020 in connection with an entirely separate earlier investigation which took place during President Trump's first presidency and had to do with the potential leaking of information to the media about ongoing investigations by the FBI. And the search warrants were focused on a Columbia University law professor, Daniel Richman, who was a friend of Mr. Comey's, but who would also end up representing him as his lawyer. And that created the question of whether or not the information might have been covered by the attorney-client privilege. The judge here raised a number of issues as to whether or not there could have been a violation of Mr. Comey's rights and whether or not privileged information might have seeped into the grand jury presentation, and that would have been entirely improper and would have tainted the presentation and could potentially be a basis to dismiss the indictment.
So, Bob, the prosecutor here, the interim U.S. attorney, Lindsay Halligan, was Trump's former personal lawyer, had never been a prosecutor before, and she presented the case to the grand jury by herself. It appears that she suggested to the grand jury that the fact that Comey didn't testify in his defense should be interpreted as a sign of guilt. Even a first-year law student should know that a defendant doesn't have to testify.
Well, that's exactly right. And the magistrate judge described these as, quote, fundamental misstatements of law by the prosecutor in front of the grand jury. And one of the issues that he identified was this Fifth Amendment right issue. Apparently, during the course of the grand jury presentation, a grand juror raised questions, as grand jurors often do, to the prosecutor, and the prosecutor has to respond with the proper law in order to give the grand jurors the framework by which to consider whether or not to return an indictment. Here, apparently, a grand juror asked a question, and as you say, the exact response has been redacted, but according to the magistrate judge, it suggested that Mr. Comey may have had a burden to explain away the government's evidence. In other words, the inference was that the burden shifted to Mr. Comey to have to explain why he did what he did, when in fact, under the Fifth Amendment, a defendant has no obligation whatsoever to testify, and the fact that they choose not to testify cannot be used against them. And more fundamentally, in a criminal prosecution, the burden never shifts to the defense. It's always the prosecution's burden to prove its case beyond a reasonable doubt. So any suggestion that Mr. Comey's decision not to testify, not to explain away his conduct, could somehow be used by grand jurors to infer that he committed a crime would have been improper. The judge also noted that Ms. Halligan may have suggested to the grand jury that they did not have to rely only on the record that was presented to them during the grand jury presentation in order to reach a finding of whether or not there was probable cause, but that they could assume and they could be assured of the fact that the government had even more evidence, perhaps better evidence than was presented to them during the presentation that could be used at trial, and therefore that the case was even stronger than the evidence presented to them during the grand jury proceeding. If that was done, that too would be entirely improper. The grand jury has to make a decision as to whether or not there is probable cause based solely on the evidence presented to them during the grand jury proceeding. It's really no different than a trial in which jurors have to make a determination as to whether or not the government has met its burden of proof beyond a reasonable doubt based solely on the evidence that's presented to them during the trial. They can't rely on anything outside of the record during the trial proceeding. The same holds true for grand jurors, and for prosecutors to suggest that there is other more powerful evidence that they should consider but has not been presented to them would be entirely improper.
I mean, her comments basically come down to a defendant has to testify before a grand jury, and trust me, grand jurors, we have a lot more evidence that will prove his guilt, but we're not showing it to you now.
Well, I think that's why you saw the opinion written by the magistrate judge to be as strongly worded and as detailed as it was. It was a 24-page opinion that went through not only the issues that Mr. Comey's lawyers had raised in order to try to gain access to the grand jury transcripts, but also a litany of other issues that he discovered when he reviewed in camera those grand jury transcripts. And he raised serious questions in his mind, I believe, as to whether or not there were serious constitutional errors in the presentation. Not only the Fifth Amendment question, not only the question that there was evidence outside of the grand jury's purview that they should consider, even the way the grand jury returned the indictment. In this case, the original indictment presented to the grand jurors was a 3-count indictment. When the grand jurors went back to deliberate, they chose not to return a true bill, which means they voted not in favor of one of the 3 counts. And now there's a question as to whether or not an entirely new indictment with only the 2 counts that the grand jurors voted in favor of was ever presented to them. If that did not happen, if the grand jurors did not deliberate on the exact indictment that was ultimately presented to the court, that is another issue that could be very problematic.
And there's a lot of confusion about whether the grand jury actually reviewed the final indictment or not, with Halligan first saying in a hearing that they didn't, and then in court papers saying that they did.
During the hearing, the district court judge was very clear in asking the government whether the second indictment containing only the 2 counts that the grand jury voted in favor of was actually represented to all of the grand jurors so that they voted on the actual indictment that was ultimately presented to the court. At that time, the government said that the full indictment was not presented, but now they've come back with evidence in the transcript that suggests that perhaps it was repackaged and presented to all of the grand jurors. So the record on this question of whether the grand jurors actually voted on the indictment that Mr. Comey is now facing is muddled at best. At the end of the day, the question of whether they voted on the actual indictment or not is probably not the issue that's going to drive the decision. The judge will more likely look at some of the constitutional questions that have been raised by Comey's defense team with regard to some of the comments that were made during the grand jury process and make a determination as to whether or not this indictment will stand based upon those arguments rather than this procedural question about whether the proper indictment was presented to the full grand jury. This is a prosecutor's nightmare. The case should not be about the prosecutor's conduct right out of the gate. It should be about the defendant's conduct and about whether or not the government can prove that the defendant committed a crime beyond a reasonable doubt. The probe into the conduct by the government is exactly where you want to be if you're on the defense side, but it's the worst place you can possibly be as a prosecutor.
Yet another judge is involved in this case, and that's the judge considering whether Lindsay Halligan was lawfully appointed.
The federal judge is actually a judge from South Carolina because the question before the court is whether or not the U.S. attorney for the Eastern District of Virginia has been properly appointed. And the decision was made by the circuit court that it would be best to have a judge not in that judicial district making this decision. So the judge from South Carolina, Judge Curry, is looking at the convoluted process by which Lindsay Halligan was appointed as the interim U.S. attorney for the Eastern District of Virginia. There had been a career prosecutor who was appointed by President Trump to serve on an interim basis. That interim basis lasts 120 days. After that time period, the judges in the district can then extend that appointment, and that's exactly what happened here with that career prosecutor, Eric Siebert. The Attorney General then fired Mr. Siebert and appointed a new prosecutor, Lindsay Halligan, for a new 120-day period. And the question is whether or not the executive branch can continue with these 120-day interim appointments sort of ad infinitum, or whether they can do it only one time, and after that time, it's up to the district court judges to appoint the U.S. attorney.
There are so many interesting legal questions in this case. Thanks, Bob. That's Robert Mintz of McCarter and English. Coming up next, a huge win for Meta. I'm June Grasso, and you're listening to Bloomberg. A landmark antitrust decision on Tuesday was a massive blow to the Federal Trade Commission and a huge win for Meta as it prevailed over an existential challenge to its business that could have forced the tech giant to spin off Instagram and WhatsApp. A federal judge ruled that the FTC failed to prove that those acquisitions allowed Meta to illegally monopolize the social networking market. The question now is whether the government will even appeal this significant loss, especially factoring in one dynamic. Meta CEO Mark Zuckerberg has been courting President Trump.
We're going to work with President Trump to push back on governments around the world that are going after American companies and pushing to censor more.
And it was Zuckerberg who was seated right next to the president during a high-profile dinner of technology executives in September. My guest is antitrust expert Harry First, a professor at NYU Law School. Harry, how big a blow is this to the FTC?
Well, it's a blow, all right. So this is the first big loss in these high-tech platform cases. So two of them have now come to a conclusion of the trial, both against Google, both successful for the Justice Department. Remedy, another story maybe. So this is the third. There are 5 total, and it's the first loss. It's sort of not a surprising loss because this judge has been skeptical of this case clearly from the very beginning. He had dismissed it originally. So he's been very skeptical, and he's said it in his opinions. So this case has not been well received by the judiciary, shall we say. So it's not surprising. The opinion itself is a little surprising, but the result is not so surprising.
Why do you say the opinion is surprising?
So in 2 ways. First of all, he's taken a very novel approach to time in the opinion. So he says that the proof has to be as of the time I make my decision almost. I mean, this is an impossible standard. He said maybe they were a monopoly. Maybe this was a properly defined product market in 2020 when the suit was filed. But as time has gone by, it's not that much time. By now, it's not. And the question is not whether it was then, but whether it is now. I mean, if you take that literally, that's a completely moving standard. You could never try a case because your evidence is always outdated. I mean, it's always about the past. You can't try a case about the future. So that's a departure. He's got some legal reasoning for why he does that, but that's a serious problem, and I think it's a serious antitrust problem. So there's that part of it. The second part is this judge is very confident of his opinion. So normally a district court judge, he's got 7 things to decide in front of him, and they proceed logically. Well, if you go for this, then you're done. But if you go for this and it's okay, you go to number 2, 3, 4, 5. So he has a long trial, but he only decides the first issue. Now, normally a judge would say, okay, here's what I decide. This isn't a market. The market has to include such and such. They don't really have monopoly power. Okay, but if I'm wrong, here are the facts that I found about the conduct. And the conduct wasn't anti-competitive. So even if you had monopoly power, this was not exclusionary conduct. It wasn't anti-competitive. And so you go through all the things, because if a court of appeals disagrees with you, now what? You've got to retry the whole case? So this is a judge who thinks, no one's going to disagree with me, man. And maybe part of it is because the narrative of the case is at least potentially stronger than the market definition. So, all the emails about how Mark Zuckerberg's theory was to buy them or bury them, and, what he tried to do with competitors and why he paid so much for Instagram and for WhatsApp. WhatsApp drops out of this case like right away. I don't know, third word or something. He says at some point, we're done with them. We don't have to talk about them anymore. So that's pretty unusual, I think. And it's either hubris or confidence. I don't know which. But he does not do what I think most district court judges would do, which is decide the full case.
I thought the focus would be on the market when Meta bought Instagram and WhatsApp, and whether it was anti-competitive conduct when it's alleged that Meta couldn't compete with these 2 apps, and Zuckerberg said it's better to buy than compete.
What he tried to say was, well, we've got to do it as of now, in part because of the FTC's remedy powers. They're asking for an injunction, and they can only stop conduct that is illegal now. So I've got to decide what's illegal now. Now, he could have very well said, that's a remedy question. We'll decide that when we get to remedy, whether it's a continuing violation or not. We should look at whether there was a violation then. So, for example, if this were a suit for damages, you wouldn't say, well, we have to see whether there's a violation today. You would say, let's see whether there was a violation at the time that the offense was committed and what damages were caused. So those 2 things are separate. So it's really quite odd. And you're right. The argument that the commission makes is that we look at what they did and why they did it, that this was an effort to maintain their monopoly, these 2 acquisitions for which they wildly overpaid. Why were they paying $19 billion for a company that didn't have any revenue? That was WhatsApp. And the answer was they didn't want them to develop into competing social network platforms. So, now that part also had problems. It had issues. The Federal Trade Commission and its earlier guys let those acquisitions go through. So there were issues with it. So in that sense, that's a really strange aspect.
As far as the definition of the market, the FTC had argued that Meta's apps, Facebook and Instagram, are primarily used for personal social networking, while TikTok and YouTube are video entertainment apps. But the judge rejected that and put them all in one market.
Yeah, so the first question, you have to show that a defendant has monopoly power in a relevant market. So he says, okay, we have to start with market definition. So that's true. That's the way it's normally done. And then he says, okay, yes, let's look at the market. He says these platforms have converged. These are all sort of similar. And particularly TikTok, was posing a competitive threat. He says people don't want to talk to their friends anymore. They just want unconnected videos. So, TikTok comes along and they're posing some threat, and Facebook responds with Reels, short videos. And so That has now changed how we define the market because users switch back and forth between the two. And we have to include TikTok and we have to include YouTube, where users switch to those videos. Later, sort of at the end of the opinion, he says, well, the argument for YouTube actually is a little thinner. But even if it's just TikTok, that's enough. We would include that in however we define the market, whatever we want to call it. He doesn't really give it a name. And at that point, if we include TikTok, then Meta does not have monopoly power. TikTok takes away too much time. All those kids are frittering away their time on TikTok instead of frittering away their time on Facebook. He had various evidence of, the willingness to switch and that people switch between those two. Now, the odd thing in some ways is if so many people are switching, how come so many people are still on Facebook? He gives 240 million active users in the United States and ad revenues of $161 billion. So when you read his description, it sounds like this is a company that is just in the throes of death from TikTok. And then he says, this is an amazingly successful product. Give people a compelling product for free, then sell ads that can be seen by millions. I guess he thinks those are good. 240 million active users in the United States. That's a lot of people. So apparently they haven't been dissuaded by TikTok, which is also free. And, they don't give all their time there. They're still on Facebook. So the argument from the government is that by incorporating Reels, they've managed to defend their core business. And their core business is social network, putting people together. And they still get a lot of people who like that product, even though some people also use different products.
Harry, it sounds like the government should appeal because of the unusual way the judge defined the market. But this is not an administration that always follows what's best for the legal landscape. So might they decide not to appeal because of political reasons?
Who knows exactly? It's hard to assess the political winds, and the winds may go the other way because, a populist wing of the party feels that these platforms have too much power and need to be cut down. So who knows exactly? But if you look straight at the legal issues, usually appeals from adverse decisions of trial courts are hard to win on appeal because they're mostly fact-based. So you have to look for legal issues. And there's an important legal issue of, whether he applied the correct standard for defining the market and for assessing when a violation occurred. And that one's sort of a very pointed legal issue. How it will fare in the Court of Appeals if they do take it, I don't know.
And does this decision have any implications for the other antitrust cases against tech platforms?
Yeah, that's a good question. Perhaps. I'm thinking of Amazon, for example. And these are platform cases. And platform strategy is you have a core product, and what you want to do is to keep people on the platform and engaged because of the strength of the core product. And you defend the core product by acquiring things around the periphery that might challenge it, or by doing things. These companies are always subject to some competitive forces, even if they're monopolists. So certainly Facebook was. TikTok did pose a competitive threat. And Amazon similarly has competitive threats to which they respond. But the basic strategy is pretty similar. And the market definition in some ways is similar because they offer a bunch of different products in the same place, much as supermarkets do, like Whole Foods, for example. So you have a, sort of core product and then other things that they offer that other firms may compete on. I mean, look at your smartphone. So 35 millimeter cameras compete on cameras, but, are they in the same market? No. So you could say this is quite similar. Yes, TikTok competes. I'm surprised Twitter's not mentioned. Twitter competes, to some extent. But these are all to some extent. And it's still Meta defending its core product in which it has a lot of power, as all advertisers know.
And there are more trials ahead as the government continues to try to rein in big tech with antitrust suits. Thanks so much, Harry. That's Professor Harry First of NYU Law School. Coming up next on the Bloomberg Law Show, a loss for Texas in the nationwide redistricting battle that it started. I'm June Grasso, and you're listening to Bloomberg. You may remember back in July when President Donald Trump pushed Texas Republicans to redraw congressional maps to give the party 5 more seats to maintain its hold on the House in the midterm elections.
5, I think we get 5. And there could be some other states we're going to get another 3 or 4 or 5 in addition. Texas would be the biggest one, and that'll be 5.
And Texas did kick off the nationwide mid-decade redistricting battle that's playing out in other states and in courtrooms across the country. But could Trump's plan backfire? This week, a panel of federal judges blocked the new map in Texas and said the old map will have to be used for the midterms. But on Friday, the state made an emergency appeal to the Supreme Court, asking it to reinstate the newly drawn congressional map. And in just a little over an hour, Justice Samuel Alito, who handles emergency appeals from Texas, did just that. He temporarily blocked the 3-judge panel's ruling and restored the map. Alito asked the opponents of the map to file a response by Monday, signaling quick action by the court. Joining me is elections law expert Richard Brofalt, a professor at Columbia Law School. Rich, this was a 2-1 decision with a Trump appointee and an Obama appointee in the majority and a Reagan appointee dissenting. Will you explain why the judges decided that Texas couldn't use its new congressional plan?
In a nutshell, the court concluded that this was a racial gerrymander and not a partisan gerrymander. And as you know, the Supreme Court has said partisan gerrymanders are not unconstitutional. There's no basis for challenging them in federal court. But racial gerrymanders can be unconstitutional and can be challenged in federal court. So the heart of the court's decision was that this was a racial gerrymander. And what did they base that on? The court said what triggered this, although we think of this as Trump demanding more Republican seats from the Texas congressional delegation, in the court's view, the Texas governor was initially reluctant to call the special section to create the map until he got a letter from the Department of Justice in Washington that said several of the Texas districts were unconstitutionally created on racial grounds. In particular, the Department of Justice focused on so-called coalition districts, which are districts which are majority-minority, but not one particular minority group. And for a period of time in the Fifth Circuit, courts there had said that the Voting Rights Act could be interpreted to require the so-called coalition district, which, let's say, is 40% black and 30% Hispanic. Neither one is a majority, but together they add up to 70%. And so the Department of Justice says, well, we see 4 districts in your 2021 map that look like they're coalition districts to us. And based on a recent decision in the Fifth Circuit, we think that makes them unconstitutional. So you got to fix it. You've got to redo those districts. So what the 3-judge panel in this case concluded is that that was what was driving the redistricting. They looked at the statements of the governor and of the leading members of the state legislature, and they also looked at the resulting map. And they pointed out that most of the changes in the redrawn districts went from being so-called coalition districts to districts in which one race or another had a majority, and often an extremely narrow majority. They said there were 3 districts. They were either black or Hispanic, where the majority group had like 15.2%. So they said the combination of the Department of Justice letter, the governor's statement calling the legislature into session, and statements by many of the leading members of the legislature, and then the districts that were created, in their minds, this meant that race predominated. The desire to create racial majority districts is what was driving this. It's true, the court said it also clearly had partisan consequences, and there may have been some partisan motivation as well. But they said the dominant motive that they found was race, and therefore this made it an unconstitutional racial gerrymander.
Even though we know that President Trump really pushed Texas Republicans, as he's continuing to push Republicans in other states like Indiana and Kansas, who've been resisting redistricting?
I think what you could say is that, to borrow from Shakespeare, the Department of Justice was hoisted by its own petard. I think when this all began, it's now like 4 months later. It's amazing how much has gone in 4 or 5 months. When this all began, maybe people thought it was too blatant to say this was all for partisan reasons. I mean, we've now been totally partisan since June of this year in the redistricting, but maybe they thought it was just too blatant to say we're doing it for partisan purposes. So the Department of Justice trumped up this racial argument. There was no argument, actually, that those coalition districts were unconstitutional. You could argue that there's no mandate that a state create them, and that's certainly true now, but there was no evidence that they were unconstitutionally drawn. Nonetheless, Department of Justice having, I think, provided this kind of pretext for the state to go ahead and do the partisan gerrymander. But given that that was the stated reason, the court was able to say, we think it's a racial gerrymander. They also made the point that the Democratic districts which were undone mostly fell into this category of coalition districts. And they pointed out there was one white majority Democratic district which was barely touched. So they do have some evidence suggesting that most of the focus of the legislature was on coalition districts and making them majority one race or the other. But I think what you've got here is this irony that at least in June of this year, the governor and the Department of Justice thought it's too blatant to do it for purely partisan reasons. So we're going to give them an anti-race discrimination motivation. And that has, I think, turned around to sort of bite them in the rear, at least for now.
Texas is appealing to the Supreme Court. What do you think will be the main question?
Well, I think the real question is, will the Supreme Court say that the lower court has made this decision too close to the election? There's this doctrine called the Purcell principle, based on a Supreme Court decision now about 25 years old, in which the court says that federal courts should not undo state election laws if they're too close to an election. The court has never said what is too close to an election, but there have been some orders from the Supreme Court in recent years that treated decisions that were within 6 months of an election as too close to an election. And the Texas primary is in March. So looking at some recent Supreme Court decisions, there is a plausible argument that this court's decision is too close to the election and therefore should be stayed. Now, the court addresses that for about 20 pages, and they make the point that the Texas plan was not signed into law until the end of August. And if you took the idea that 6 months is too late, it was almost too late as of the moment the Texas redistricting was signed into law. It would have been impossible to have a challenge, have the parties do the research, have a hearing and have a decision in time to take something like 6 months. So the court makes kind of a strong pitch for saying that the Purcell principle has to be handled flexibly. We've got to look at how late the Texas legislature did this. And we do have to say that it is possible to come into compliance. They make two more points. One is that the old map is still in existence because Texas is about to hold an election on that old map in January because there is a vacancy. A member of the Texas congressional delegation died early this year. There was just a primary, I think, to fill that. The general election to actually fill that seat won't be until January. That's on the old map, the pre-gerrymander map. And so the court says, well, the old maps are still the law. So under our preliminary injunction, we're just going to continue to live by the old map. So the old map is still on the books. And so they're saying that in some sense, the real disruption was the state legislatures acting so late. And so therefore, we should be able to do this. And yes, it's still time for everyone to come into compliance to file under the old maps. I think the first question, maybe the stronger argument, what the Supreme Court will do is unclear, but there is a plausible Purcell argument that it's too late. But as I said, the court is very strong in saying, well, if that's the case, you can never bring a challenge to a gerrymander. That indeed, it's an incentive to do the gerrymanders closer and closer to the election to make it impossible to bring challenges.
If the Supreme Court says, forget the Purcell principle here, how do you think they would rule on Texas's appeal, that this was a partisan, not a racial gerrymander? Do you have any idea on that?
It's really hard to say. I mean, I think the court acknowledges that there's evidence on the other side, but they have, in particular, the testimony of the map drawer, the Republican specialist who was hired to draw the map, who said, no, I never looked at race data. The court said, we essentially don't believe you, partly because there were discrepancies between your testimony and the testimony of the state legislator who hired you, but also because we just don't believe that you could produce 3 districts that are 50.2, 50.3, 50.4% majority. I think 2 were Hispanic, 1 was black. I'm not sure about that. And that's so precise, and you could do it 3 times, and that you were not paying attention to race. But, I mean, there is counter evidence. You know, in theory, the Supreme Court's not supposed to judge the evidence. That's really for the lower court. They're supposed to defer to lower courts on evidentiary findings, but the current Supreme Court has not always followed that rule. So it's hard to tell what they're going to do.
As you know, California has approved a redistricting plan that would offset the Texas map, which is now in serious jeopardy. Tell us about the legal challenge to California's redistricting from California Republicans and also now the Trump administration.
I mean, they're basically making the same argument that prevailed here, that this is a racial gerrymander. I mean, they can't bring a partisan gerrymander argument because, as I said, the Supreme Court in the Rucho case in, I think, 2019 said those are simply not justiciable. You can't challenge. So I think they're bringing a claim that the legislature's motivation was race. Assumably, they've targeted specific districts. But I think the essence of it is that it's a racial gerrymander. The basic idea is similar to the argument that the 3-judge court in Texas recognized in striking down the Texas gerrymander.
Only the gerrymander is sort of going in the opposite direction. The Justice Department argued that California's map illegally bolsters the voting power of Hispanics in the state.
Which is interesting because, of course, in Texas, one of the arguments Governor Abbott made is that this is going to actually strengthen the voting power of Hispanics. Although he combined that, basically Hispanics are becoming more Republican, and this is going to allow them to be able to articulate that in districts, to vote their preference in districts. He had a sentence which kind of combined the two in one sentence. So, I mean, much would turn on whatever evidence they have for that. There's also an argument, there's been a lot of debate about this amongst the law professors, as to what's the significance of the fact that the California redistricting was approved by the voters. Would the challengers have to prove that the voters were racially motivated as opposed to the legislature? And I think it's up for grabs because the public campaigning was largely on party grounds. So whether or not, even if there was a racial motivation within the legislature, whether that was some kind of washed away by the voters, or whether if it really is racially tainted, whether the legislature's motivation was racial, pro-Hispanic, whether it doesn't matter that the voters voted for it because they thought they were voting on partisan grounds. That will be an interesting fight.
You law professors have some interesting conversations.
Yeah, obviously it's been all online, but it's been an interesting back and forth. Of course, the government and the plaintiffs first have to show that the plan was racially motivated and not partisanly motivated, even within the legislature. And then if they conclude that it was partisan even in the legislature, then the effect of the voters becomes irrelevant.
Thanks so much, Rich, and for sharing those professorial insights. That's Columbia Law School professor Richard Briffault. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.